I'm Matthew Doman. I am the South Australia and Northern Territory Director of the Australian Petroleum Production and Exploration Association, otherwise known as APEA. With me is Adam Welch, our Policy Director, who is assisting us in relation to this inquiry and matters more broadly in the Northern Territory.
Thank you. Yes, when you're ready.
Thank you. Firstly, we acknowledge the Larrakia people, the traditional owners of the land on which we meet, and their elders past and present. The Australian Petroleum Production and Exploration Association again acknowledges the panel members' contributions of time and expertise to this inquiry. Your draft report represents the culmination of a significant body of research, investigation, consultation on the potential for an onshore shale gas industry here in the Northern Territory. Since publication of the draft report in December, we've reviewed your 120 recommendations in detail and made a written response to each of them. An onshore gas industry in the Northern Territory can bring significant economic and social benefits to the region. Importantly, many of these benefits will be in remote communities. These benefits will not only be jobs, but also in the form of opportunities for partnerships in development, improving infrastructure and investment potential. APEA members are committed to building long-term relationships and being active members of the community. I won't make a lengthy opening statement today, but instead leave as much time as I can for your questions. There are just a few points I'd like to make before that. There's been some discussion yesterday and this morning on the direct and indirect benefits of onshore gas development. You've expressed a desire to see more detail on how these benefits have been delivered in other jurisdictions and prospectively what may occur here in the Territory. In respect of Queensland, I draw your attention to two documents and happy to provide copies. APEA's November 2017 report to the COAG Energy Council on onshore gas in Australia. This shows Queensland's oil and gas industry in 2016-17 employed some 27,000 people, including 23,000 indirect jobs, many in regional areas. That is outlined on page 25 of that report. Now, those numbers are down slightly from 40,000 total jobs in 2015-16 and 35,000, including 35,000 indirect jobs in that year, reflecting that the construction phase in that industry is winding down. The COAG report also shows that $15 billion of industry investment has helped sustain 3,100 Queensland businesses, and that's outlined on page 5. The second document is APEA's submission to the so-called Lazarus inquiry, not its correct name, into unconventional gas in the Australian Senate. Page 61 to 64 of that report outlines over $38 million in contributions made by Santos GLNG alone to community initiatives, and Santos spoke to some of those this morning. Despite claims to the contrary, the overwhelming evidence is the natural gas industry has delivered significant benefits to the regions which have hosted its operations in Queensland. But we also understand your concern to understand better how our industry will develop in the Northern Territory. What will be the Northern Territory Way and how will it impact communities? This concept of the NT Way was outlined in Pangaia's initial submission to this inquiry, and I note that terminology has been used repeatedly in your draft final report. Industry will continue to develop this plan and pursue settlement of the Northern Territory Way as we adjust our operations to the appropriate environment here in the Territory. We'll continue to develop those plans if and when we're permitted to resume our activity. Already you've seen from our member companies such as Central Petroleum and Pangaia a commitment to creating local opportunities, including training and employment schemes for Aboriginal Territorians. Since taking operatorship of Mereenie 2 years ago, Central has reduced its FIFO workforce by two-thirds, and most of its staff are now Northern Territory based. Origin has recently awarded a maintenance and monitoring contract to an Aboriginal-owned business in Elliot, known as Triple P, and that has supported full-time employment and direct participation in that company. Other companies will seek to maximise local opportunity as we build our business here, but we can't do that while the moratorium remains in place. The draft report has investigated a broad range of concerns with developing onshore gas industry in the Northern Territory. All of the issues raised can be mitigated or completely removed by creating and maintaining proactive collaborative partnerships, holding an unwavering dedication to high performance standards, and implementing a robust and efficient regulatory regime. We are committed to working with the Northern Territory Government, the community and other stakeholders to ensure such a framework is maintained in the Northern Territory. The industry supports robust, effective and efficient regulation and oversight. We believe that many of the draft reports and recommendations are broadly appropriate to achieve this. However, in some cases, the recommendations are inconsistent with the very small footprint and overall environmental impact of the industry and do not apply to industries that may have higher environmental impacts. We agree with the draft report's finding that exploration and appraisal activities are vital in further developing our understanding of the region's environment, geology and water resources. This exploration activity is low risk and should proceed while the recommendations of the inquiry are considered and implemented. With that, I'll end our opening remarks and allow time for your questions.
Yes, I do have one question in relation to, and thank you very much again for actually going through and engaging with each of the recommendations. That's enormously helpful. In relation to your response to the recommendation that there be open standing, you've objected to that. Can you just explain why and what you mean by foreign residents or international activist groups?
We've seen some foreign residents, some foreign owners of pastoral properties who've taken an unconstructive attitude towards interaction with some of our member companies. I think there was an example given by Santos earlier in this process. We've also know that some of the groups campaigning against the development of natural resources in the Northern Territory linked to international organisations receive significant foreign funding, and I don't think meet a definition of a directly impacted member of the community, someone directly impacted by the development in here in the Northern Territory. Many of their leaders, like myself, live in southern states, visit the Territory to pursue our work, but we're not members of this community, and I think our responses and views ought to be borne in mind in that regard.
Certainly the evidence when you look at the numbers from, say, the EPBC Act, which has not completely open but very broad standing provisions, and indeed the statistical data coming from the Land and Environment Court, where there is open standing, indicates that these types of spurious or perhaps factitious or litigation or even strategic litigation simply aren't there. They don't occur. And there's all sorts of good reasons for that. Litigation is costly, both
Correct.
Financially and
Correct.
Emotionally as well.
Yeah. I note your speech, Ms. Onest and Mr. Neal, that was attached to the draft report and makes those same observations. I think importantly...
I think it was referenced in the draft report. I don't think it was attached to the draft report.
I discovered it via your report. And you do make acknowledgement there of this issue that one of the advisors to, I think, the Conservation Foundation, was it? Federal Court Judge Murray Wilcox observed in his submission to the Senate inquiry in the EPC Standing Bill that he has, as a lawyer, had to give counsel to some opponents of development to proceed with great care because, as he outlined the sober facts, if the action fails, the applicant would be ordered to pay legal costs. Now, my understanding is also that one of your recommendations is that those who appeal against our approvals, if they are granted, not face legal costs in doing so.
No, with great respect, you mischaracterised the recommendation. It's in cases of genuine public interest. And when you look at the jurisprudence, again, emanating from my court, the Land and Environment Court of New South Wales, there are very stringent criteria to prove what is genuine in the public interest. Merely putting your hand up and saying, hey, I care for the environment is absolutely not enough. and more often than not, costs are awarded against the unsuccessful litigants. But it does add that layer of protection where you have a significant, new, important, sort of novel point that needs to be tested in the court. So again, I come back to the data, the hard data, and the courts are simply not being flooded by these types of claims. But it does allow the public a degree of comfort knowing that these decisions can be challenged. And again, there's a wide body of material that suggests that where you have open standing, where you have greater access to justice, governments make better decisions. Any decision that's about to be scrutinised and where a government knows it's going to be scrutinised ends up being a better decision.
We accept that. We also accept the requirement or the need to have rights of appeal if due process has not been followed prior to any environmental approval.
Of course.
But the opportunity to essentially re-prosecute a decision about approval, which has taken due consideration of all the environmental impacts, the community impacts, has been through the rigorous environmental approval process that is being enhanced here in the Northern Territory. If that decision has been made consistently with those processes, we don't see a need or that there should be an opportunity to essentially appeal an umpire's decision simply because you don't like that decision.
Where it's been made unlawfully, though, you would have to accept,
Absolutely.
Would you not, that there should be a right to challenge that decision?
Absolutely.
And if indeed it proves that that decision was made wholly lawfully, then that will no doubt have consequences for the unsuccessful party.
That's right, as we've seen around in a number of cases around Australia in recent years that are referred to in your presentation here, and I'm sure known to all of us.
Thank you. Any? Yes, Professor Hart.
Mr. Doman, can I just continue on with the exploration activities at the same time as Cereba? You've heard a number of presentations today where groups have disagreed with that. They believe that Cereba and some of the regulation should be put in place before any more activity occurs. Can I get you to give us an idea of what you see as the scale of that exploration activity in the 2 or 3 years that these things might take to put in place?
I note that the companies, I think, the three, let's call them lead proponents in respect of the Beetaloo at least, Santos, Origin and Pangaea, I think have outlined their broad exploration plans to you. I don't have specific information beyond that. What we do repeat is that the relatively small number of wells that are drilled in that exploration phase, I won't offer a number because it may mislead, but significantly less than occurs in the development of those gas resources. The information gathered during that exploration phase, as we said, on the geology, the water resources, and indeed the gas resource, is critical determining the scale of development, or for that matter, whether there will be any successful commercial and environmentally sustainable development. We're committed to sharing the information we gather as that exploration activity continues, and we think it happens very comfortably alongside the gathering of deeper baseline information as you've outlined in your report.
Yes, Dr. Jones.
Just pursuing that one a little bit more, I think when we think about exploration, typically people think of mining exploration or gas exploration as putting down the odd hole here and there and not too much for footprint. But when we talk about appraisal in terms of developing a gas field, then it starts to become somewhat bigger. And I think that's perhaps where the main concern is, and it's that sequencing of how long the single hole type exploration takes versus the multi-well appraisal phase. And I think people justifiably have some concern perhaps about establishing baselines before perhaps that larger footprint starts becoming established, and that's where the sensitivities rise, I believe.
I think that's true. It still remains the case that it remains the case, and I think this is often misunderstood, not by the panel but in the broader discussion, that if a decision is taken to lift the moratorium that's currently in place and our exploration activity resumes, that the next day that activity will resume. Each specific activity we undertake requires specific environmental approvals. It takes time for those approvals to be obtained, and regulators, the government has the opportunity to assess those case by case during that exploration phase. That's appropriate. When we move to larger scale development, of course, we submit a full development plan and environmental impact statement that again is assessed in great detail prior to the activity going ahead. So, I think in the broader public discussion, it's important to understand that if there is a decision to lift a moratorium, that's not a green light for specific activity. That's still subject to very close scrutiny, review, and specific approval processes.
Yes. Yes, Professor Moxley.
Yeah, Mr. Doman. There are a couple of places in the recommendations where a setback distance has been prescribed. Do you have any comment to make on those setback distances and the way in which they're actually defined?
So we have said we don't support prescribed setback distances. We do accept, and it is standard operating practice for us in the industry, to have appropriate distances back from any residences or other facilities or amenities. We do think that they ought to be determined in consultation with the landholder and representatives of the community or other users of that land. There may be places where, for example, I think the setback from residences proposed is 1,600 metres. We accept the concept of not being an impact of our facilities on the occupiers of those residences, but whether that's achieved with a 1,500 metre setback or a 1,700 metre setback, we think can be determined in consultation with the landholder and with the regulator. And so we don't think that a specific prescribed distance is necessary. But in other jurisdictions, and Adam, correct me if I misspeak, we do find that there are setback distances defined, whether we like it or not, and but they are typically, I think, in 1 kilometre is the distance. I think in Queensland, stand corrected if I'm wrong. Our observation would remain the same. We maintain our opinion on those regulations, but we're not the regulator, and we have to operate within the rules that are put in place.
Any further questions? One last question, Mr. Doman. Well, no, I'll let you go first. Go ahead, Dr. Beck.
Right. The panel has heard very passionate arguments being put forward for the need to have baseline conducted prior to any exploration and appraisal. And that's been a very strong message, very impassioned, very, as I said, heartfelt. And the panel will be considering those propositions that have been put to it. Does the industry find any accommodation for those concerns that have been very, very genuinely expressed, and can APIA, on behalf of the industry, try to find some accommodation for having baselines conducted prior to exploration?
I think time, appropriate amount of time needs to be taken to conduct extensive and sufficient baseline studies. The activity that we propose during exploration helps gather some of that information. It doesn't prevent the gathering of that information, and we think there is no need to delay exploration activity while that takes place. It only extends the deadlines, the timeframes. It only extends the timeframes towards development. The industry is not the only beneficiary of that development, as we've tried to point out in many instances, including through the course of the inquiry. Delaying that activity and the benefits that flow from it, I think, is is of itself not an aim, and I don't think the exploration activity that we propose prevents the baseline studies from occurring, or is necessary to be suspended prior to that taking place. We heard a submission from Lock the Gate this morning that if a company had invested significant money in an exploration activity, that somehow they would be, and then were to propose appraisal and development application, that somehow they would be a proponent that could not be resisted because we had invested so much money and we had made such an effort during the exploration phase. That is not our expectation whatsoever. We know that we face the requirement for approval before we move into that production phase. We've seen that in New South Wales and other areas where Santos has invested considerable money in the Narrabri region in developing the Narrabri gas project. They do not take for granted that that project will be approved. They've lodged their environmental approvals for that project, but it is far from certain. Certainly we hope that will be approved, but that is a decision for the regulatory agencies of the New South Wales Government. It's not a certainty that because we've been such good explorers that we'll automatically be granted development and production licences.
A couple of observations. If this proposal goes forward, that we have a Cereba which is going to impose much more stringent baseline monitoring with potential significant implications, then I think what you're saying is the companies are prepared to accept a higher risk of a negative outcome, because if these were to go ahead, they're going to change the ground rules in terms of what is going to be monitored, and it's going to be more extensive, and you industry then subject to the possible implications, which raises your risk profile. I just wonder whether you've fully thought through the implications.
I think
that's one thing, but if I can finish. Yep. And secondly, there's been a continual issue of industry being a need to have a social licence to operate. Mm-hmm. And we've been talking about this for many months now. I wonder whether some of the attitudes that I'm hearing from industry are conducive to gaining a social licence to operate.
So on the baseline study piece, first of all, I mean, there is no resistance from our industry to the gathering of baseline studies. I think it's fair to say that we, in hindsight, would have rather gathering more extensive baseline studies prior to full-scale development in other jurisdictions as well. That wasn't done, but we have the opportunity here in the Northern Territory to do that. I think that's one aspect of the Northern Territory way here, that we can, in the Beetaloo, gather stronger baseline data before entering into that into full-scale development and production. We wouldn't support the gathering of baseline data if we intended to ignore it or seek to not respond to its findings. If that baseline data and other work proves that our activity is not appropriate, can't be conducted safely and sustainably, we would listen to that data. We would respond to that information. We would adjust our plans accordingly, and I would expect we probably wouldn't get approval to conduct the activity we propose. So we know that we're in an ongoing dialogue with the community, with the regulatory agencies of government and others, and that dialogue needs to be informed by information. We need to share information that we have. We need to support the gathering of information by other agencies that can also be shared and factored into the decision making. We are very confident that we can operate safely and sustainably in the Northern Territory, as we do around the country, and we're very keen to establish a framework here that enables that to take place, that builds community support. Community support, which will continue to be portrayed in some sections as being absent. We will continue to have, I'm sure, in an increasingly ideological international energy debate, people who are very strongly opposed to the use of fossil fuels in any way, shape or form. And that's an appropriate view to hold. It's not a view that I or my members hold, but it's not an illegitimate view, and they're entitled to express that view. I think we also need to cut through when other issues are presented as being obstacles to development, really only for the purpose of achieving the objective of ending all fossil fuel production. So I think, legitimate local environmental issues have to be properly addressed. False and exaggerated claims about incidents, and I feel that we've seen one of those today, and an orchestrated attempt to leverage that information to influence the broader community debate here, that will continue to happen, and we need to respond to it. Many will say and observe that we need to respond as an industry better to it, and I'll wear that criticism. But we, as I said, we need information, we need to share information. It won't be just in the timeframes of this inquiry, it will be as long as we seek to operate here in the Northern Territory.
I would not characterise all of the submissions and the hearings that we've heard as being intended to stop the fossil fuel industry. There have been many genuine commentary.
Absolutely.
In terms of a concern to get that baseline first, without the expectation that will stop the fossil fuel industry in its tracks.
No, I didn't intend to say that, and I apologise if that was the impression I created. There are many, many people in the community who have genuine questions and concerns, and we understand that, and we're committed to responding to them.
Mr. Doman, when does exploration stop being exploration and become quasi-production? I mean, if you've got 50 or 60 exploration wells spread out across a particular area, surely, those the impacts start to add up, the risk starts to magnify. Why shouldn't, as many of the submissions have been put before us in the last 2 days, why shouldn't we perhaps revisit whether or not a SHREBA should apply prior to exploration, if that's going to be the number of wells, or potentially the number of wells, exploration wells, that'll be drilled?
Well, firstly, the regulatory agencies have the opportunity to approve or not approve every single exploration that is drilled, a well that is to be drilled. If there were to be a concern that the cumulative impacts of exploration were reaching a stage where those approvals weren't granted, that is in the hands of the regulator. It is our firm belief, however, that that's not the case, that our exploration activity is a limited number of wells with a small footprint, that is helping build our knowledge of not only the commercial aspects of development, but of the environmental aspects of development, and along with baseline studies, builds our knowledge and enables informed decisions at a later date around whether full-scale development be permitted or not. Again, we believe there's ample evidence to support the fact that there'll be significant economic and other benefits from this activity. So that activity ought not be delayed for the sake of actions that somehow appease some sections of the community that aren't based in science, that don't reflect environmental impacts or environmental performance. Delay for the sake of delay will ultimately, well, at least delay, but possibly prevent this activity occurring at all.
I'll go to Professor Hart, and then I'll come back to my last question. Thank you.
I'll just follow that up, if I may. So as you rightly pointed out before, any exploration activity still needs an environmental management approval. But let me put it to you that at the moment, that approval is within the mining agency, and there have been lots and lots of concerns about that. I put to you, again, this is in terms of the rollout of some of our recommendations and the like. What would you say if one limited exploration approvals until possibly our option one, which is the separation between DNRM and the environment, so that the actual environmental approval would be within the Environment Department?
For exploration or for?
For exploration.
Well, we don't believe that's necessary. We don't believe that delay is necessary. We believe that in the current exploration phase that the industry is in, the current regulatory agencies have done their job adequately.
But with respect, we're talking about social licence. We've heard so many times that the approval, particularly the environmental approval process within the Natural Resources and Mines Department is not trusted. So I'm suggesting to you that there's a way ahead that may be a preferable way.
I think that the recommendations made in your report need to be considered and implemented as expeditiously as possible. I don't think that it is necessary to delay appropriately approved activity. The idea of delaying activity to appease some in the community who oppose that activity, I don't think is a constructive one. I think we need to put regulatory...
Surely some of those people are there they're there because they want to protect the environment. They want to protect a territory way of life. They want to protect brand. They want to protect tourism. I don't think they're there just to delay for the sake of delay.
The assumption is that we don't want to do those things, and I reject that. We want to do those things as well. We have high environmental standards. As we have said already, we're very supportive of taking the time to adjust the regulatory framework prior to production, to conduct the baseline studies prior to production. We do not believe that the limited activity occurring during the exploration phase will have negative environmental impacts, automatically lead to, assumes that future production approvals will be granted. And I don't think a freeze on that activity will assist anyone who is relying on the future energy flows that will come from the Northern Territory. People are looking for employment and economic activity in the Northern Territory. We've already seen, we see a challenging time for the Northern Territory economy. Our activity, albeit limited during exploration phase, can have an immediate impact on economic activity, including in the regions that would host development. I don't want to dismiss the alternate view as always being an emotional one or an extreme one or an unreasonable one, but I think we have to balance the needs of our needs to secure energy supply, our needs to secure the economic footing of the Northern Territory, with the objective of, at all times, protecting the environment and existing industries here in the Northern Territory. I don't believe, if you're proposing a continued freeze on exploration activity, that achieves the environmental environmental objectives
but I
at all.
don't think we're in any way suggesting, not in these questions anyway, a continuation of freeze. What I'm trying to put to you is that maybe there's a better way. You used the word appropriate approval. I think there's many submissions we've had that says that the approval process at the moment is not appropriate, at least from the environmental point of view. And we have potentially a way that could make it a little bit more acceptable to some of those who don't trust.
So we don't concede, and we don't agree with that view, that the environmental approvals are not appropriately granted. I don't think that claim is made about the Origin Tamungi well that was the most recent well that was drilled.
I'm not talking about that. No, I'm talking about... So you don't agree with our last recommendation of the option of separating, or the necessity perhaps of separating the technical approval from the environmental approval. I mean, that's the gist, absolutely the gist of the last of the regulatory recommendations. So you don't agree with that?
It's 14.31, and I think you've said you don't agree with that on page 28 of your submission.
That's right. That's right.
I just don't understand how it could ever be a good thing for the same arm of government that promotes the industry to be the same arm of government that is responsible for compliance and enforcement.
Well,
very few. In fact, I'm struggling to think of another jurisdiction where that occurs.
We believe that the regulatory framework that applies in South Australia and has applied and evolved over decades is a very good one, and it's demonstrated to be effective. The agency, and this observation is made frequently, the agency that that regulates the industry is the Department of State Development. So, in its very name, it is committed to the development of the state, and some believe, as you're suggesting and as your recommendation, that that's not appropriate. I don't think that we have seen any regulatory failings by that agency in South Australia because they are housed in the same department as the Department of State Development. That ultimately, though, is a matter for government and the structure of government, and we don't make those decisions. We will have to accept those decisions. We do support a single regulator. We don't insist that be the same agency that also promotes development. Arguably, the department here in the Territory doesn't promote development. It contains the NTGS, which provides information which may facilitate investment decisions, but the Department of Business, for example, is a much stronger, containing the Northern Australia Development Office and other agencies, a much more stronger pro-development agency than our regulatory body. But so we've made our comments in our written submission on that. We'll await the final decision, but I suppose the example of South Australia is my best response to, do we see a problem with the regulatory agency also having a promotional activity? No, we don't. We don't demand it. We don't necessarily expect that continues, but we do believe that the single regulator model applied in South Australia for decades is a good one.
If I can just add, Chair, the Fraser Institute annual petroleum survey of international petroleum risk of different jurisdictions has consistently ranked South Australia as the best Australian jurisdiction on an overall regulatory framework.
So is your submission ultimately then to this inquiry that we should adopt the South Australian model?
I think we've consistently urged reference to the South Australian regulatory model. We're somewhat beyond that point now with your draft final report and your specific recommendations, so therefore we've adjusted our position to response to your recommendations. We continue to say that there are many good things about the South Australian regulatory model. I think many of your recommendations go towards aligning practices in the Territory with jurisdictions such as South Australia and Queensland, which have had a longer experience of oil and gas, onshore oil and gas activity of significant scale. They're largely recommendations that we have supported in your report. So, sorry, if the question is, do we think the South Australian model is a good one? Yes, we do. I think we're at a moment now where you've suggested a framework with quite specific detail, and we're responding to that.
So do I take it from that answer then that you accept that there is work to be done in strengthening the regulatory framework in this jurisdiction?
I think that's, to the extent that we've accepted many of your recommendations, that work ought to be done. And again, to go to your point, that's building confidence in the regulatory regime in the Northern Territory is important. We will do all we can to work with government and its agencies to achieve that. We believe that will take time. We believe that must be in place prior to production licences or production approvals being granted. We believe that exploration activity ought to be able to continue while that work is being done.
That last point, puts you at slightly odds with some of the submissions we've heard from some of the gas companies before us over the last 2 days, which is that there should be some grey area or exceptions to allowing the regulatory reform to take place while still having some production occur. So you would obviously disagree with that position from the gas companies that have put it before us.
To clarify, are you talking about production testing during an appraisal activity?
Well,
which is
I guess I'm asking you.
Which is consistent with an exploration permit? Is that the sort of reference you're referring to?
I'm asking you. So where do you say that the regulatory reform should be allowed to continue in parallel with what process? With exploration, with production, with with production testing? Where do you say it should?
Well, I think production testing is part of exploration activity, and the very small amount of gas that is produced in that process is important to building our knowledge of the gas resources and the commercial sustainability of their production. I think that is understood to be part of the exploration and appraisal activity. If you are going to drill a significant number of wells to deliver a defined amount of gas into a commercial market, and you're submitting an environmental approval to do that, I think that is the point at which we would expect to be doing so under a new regulatory regime.
Thank you for that point of clarification. Thank you, gentlemen, for appearing today.